Alrighty. We've got wildlife guy who believes that he knows what's going on because reasons. So let's read what he says. In California, dat man was arrested in California. He falls under SB 411, the Right to Record Act. Doesn't matter where the California citizen is. Private, unposted property, public property, doesn't matter. The California law clearly states right to be and right to record. Can't argue when the law grants a right to the people. Do citizens have a right to be in the post office? If so, they can record that in California. It's a right given by law. Dat man was cut loose with the threat of being charged with trespassing on public property. Was dat man actually charged or just detained and set free? So, we've already covered in a previous video the right to record in a post office. But let's look at what he says here. So, he falls under this SB Right to Record Act because he's in California. Well, my good friend, the Constitution of the United States says, this Constitution, that we're in Article 4, they typically call this like Clause 2 or something like that. This Constitution and the laws of the United States, which shall be made in pursuant thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land. And the judges in every state will be bound thereby, and anything in the Constitution or laws of any state to the contrary notwithstanding. So what this says is, and it's generally been interpreted by the Supreme Court to mean this, so this is actual, here you go. The Constitution is the supreme document of the land. After the Constitution, you get all the laws and the treaties. They're basically equivalent. It's whichever one was the most recently passed is the current law. So if there's a law in conflict with the treaty, whichever one was the most recent one passed is going to be the controlling document. So that's and then after that it's like the executive orders, and then state constitutions, and then state laws, and then probably local laws or whatever. But yeah, that's the Supremacy Clause. So well, my little buddy, federal law trumps state law. In the federal law that we had, I'm doxing myself. Oh no. And I've already showed this in another video, but it's the 39 CFR 232.1, conduct on a postal property, subsection H, 5I, and it's except as prohibited by official signs and directions of security force personnel or other authorized personnel or federal court or rule. Photographs for news purposes may be taken in entrances, lobbies, foyers, corridors, or auditoriums when used for public meetings, etc. So you can't win this one, my boy. But here is a lovely piece of advice for you. A Senate bill is a Senate bill. So every year they start Senate bills, California State Senate. They'll start at Senate Bill 1, Senate Bill 2, et cetera, et cetera, et cetera. And they're meaningless. Senate bills that haven't been actually passed by the Senate are still Senate bills. They have to be passed by the California State Senate and then signed by the governor in order to be law. So then you have the law section. So what this Senate bill did is it modified Penal Code 69 and 148. It added these two things. So let's actually go to 69. This is what it added. The fact that a person takes a photograph or makes an audio or video recording of an executive officer while the officer is in a public place, or the person taking the photograph or making the recording is in a place he or she has a right to be, does not constitute in and of itself a violation of subsection A. But that doesn't mean it can't be a violation of something different entirely. So it may not be violating subsection A, but that's trying to deter an officer from performing a duty. But it can still be a violation of other things. Then we go to 148G. That's the other thing it modified. So it's section 148B. And then it also changed 148G. We'll go to 148G. The fact that a person takes a photograph or makes an audio or video recording of a public officer or peace officer while the officer is in a public place, or the person taking the photograph or making the recording in the place he or she has a right to be, does not constitute in and of itself a violation of subsection A. Nor does it constitute reasonable suspicion to detain the person, or probable cause to arrest the person. So this is saying that it's not obstructing a police officer, resisting, delaying, but it could be other things. So the fact that they're recording in and of itself isn't prima facie evidence that there is obstruction of justice going on. So they can't say, oh, you're obstructing a police officer simply because you're recording. But they can say that if you are recording in violation of something else, let's say that you are trespassed from a police station or trespassed from a library, which you can be, then if you go back onto that property, this wouldn't help you because you're on the property to record. And yeah, that's not in and of itself doesn't constitute a violation of this, but it would still be a violation of the trespass. It wouldn't in and of itself be resisting or delaying or obstructing a police officer, but it would still be a trespass, violation of the trespass. So that's where Wildlife Guy is wildly inaccurate. No law passed by California will ever override a federal law. If the federal law chooses to occupy the field, then it 100% occupies it. If the federal law may allow states, it may set a floor that the states can then go over as far as like protections and things like that. You'll see that with various things like California, their cars, they have to exceed federal minimums. But a California law will never override a federal law. Now there's federal and state trespassing laws. So I'm not sure. I don't follow that man. So I'm not sure whether he was arrested by the local police or arrested by a postal inspector. I don't know if he's been threatened with a federal trespassing charge or a state trespassing charge, because there is a federal trespassing law and there's a state trespassing law. I'm not sure which one they're gonna go with. But just because he's been released doesn't mean that they can't subsequently charge him. They can always file charges later. They may want to review it before they file the charges to make sure, because you got to remember, nothing that I say is predictive necessarily of the future. A future Supreme Court may hold that you have an absolute right to film at a post office or whatever. But what we do know, Wildlife Guys specifically, is that a California law cannot, does not, and will not ever trump a federal law. That's Constitution. That's long settled. You're not going to win it. I'm sorry. I know you hope for that man, and you know I'm all for First Amendment filming, but if he did actually violate the law, that's just going to be the way it's going to play out. Maybe it'll go to the Supreme Court and something will get changed. You can always hope. All right, take care.